Roe v. Wade, 1973.
For Roe, under the Bill of Rights, a woman has the right to terminate her pregnancy. It is improper for a state to deny individuals the personal, marital, familial, and sexual right to privacy. Moreover, in no case in its history has the court declared that a fetus, a developing infant in the womb, is a person. Therefore, the fetus cannot be said to have any legal right to life. Because it is unduly intrusive, the Texas law is unconstitutional and should be overturned.
The state has a duty to protect prenatal life. Life is present at the moment of conception. The unborn are people, and as such, are entitled to protection under the Constitution. The Texas law is a valid exercise of police powers reserved to the states in order to protect the health and safety of citizens, including the unborn. The law is constitutional and should be upheld.
In Texas, state law prohibited the termination of a pregnancy by artificial means except when the life of the mother was in danger. The statute was construed as a nearly complete ban on abortion. A Texas woman claiming privacy as a fundamental right challenged the Texas statute. In 1971, the case was argued before the Supreme Court. In 1972, it was argued again. Roe and a companion case from Georgia, Doe versus Bolton, were the first cases to test in the court the newly recognized right of privacy against the compelling interest of the states to regulate abortion.
Vote of 7-2, with Justices White and Rehnquist in dissent. The court agreed with Roe and upheld her right to terminate a pregnancy in the first trimester, which is 90 days. The court observed that Section 1 of the 14th Amendment contained 3 references to, quote, person, end quote. Hey, I'm here with Sarah Weddington. I was going to ask you a few questions about the case. How did you get involved in it?
Well, I was part of a group of graduate students at University of Texas at Austin, where, like at many other schools, we were gathering information about abortion providers, both in places where abortion was legal, like California and New York, and also in places where it wasn't legal, like Mexico. When people called for information on providers, we wanted to give them the names of the safest places. We wanted to distribute the provider information to the newspapers, but we were worried that we might be charged as accomplices in abortions if we spread the word. When I went to the library to see exactly where the law stood, I started finding cases challenging the anti-abortion statutes in various states, including the Griswold case. And we decided we would file a lawsuit challenging the Texas statutes. Lots of people ask me why the case fell to me. It's because this group decided we wanted a woman to take it, and we also wanted someone who'd do it for free. Soon after that, a young pregnant woman came to an attorney in Texas, and he told her, look, if you want to do an adoption, I can help you. If you want an abortion, I can't help you. But I can send you to 2 women lawyers, myself and my friend Linda Coffey. And that woman contacted us and became Jane Roe.
I'm with the second lawyer from the Roe case, Linda Coffey. I just have one quick question for you. New poll numbers, they show the support for abortion rights, and right now they're waning somewhat. Down from a high point in the early 1990s, what do you think is the root of the shift?
I think Americans don't want the government making the decisions for us, but we want the decision to be made carefully. So when people are asked about a 24-hour waiting period, they think, well, sure, a woman should have to wait to make sure she's making the right decision. But the problem is those waiting periods are instituted primarily in rural areas by abortion opponents. So for a woman who's traveled for the procedure, that's another day of traveling and related expenses. These little nuances can have a major impact on reproductive rights, but the public doesn't want to see them as major obstacles unless they consider them an extent of other restrictions. So they're asked if they object, and they think, why should I?
This segment of Roe v. Wade is brought to you by Sunshine James, Allie Burke, Matt Hinger, and Noah Tiemann. Shady Coat Productions.